Welcome to this interview practice session where today we'll take a look at some questions and model answers focused on the conflict avoidance and dispute resolution competency. And this competency falls under the RICS mandatory competencies and is applicable to all pathways. And the following questions and model answers are really designed to cover this area in detail to help candidates feel better prepared for their final assessment interview. So without further ado, let's go straight into the Q&A practice. The first question we'll take a look at is a very high-level question asking our understanding of what procedures can be adopted in order to avoid disputes. And to address this kind of question, we could first of all make reference to clear contract documentation and terms of engagement, and effective communication procedures between all parties, accurate record keeping such as professional diaries and site project meeting minutes, issuing written correspondence to confirm actions and decisions taken, including any site instructions, following company and contractual procedures and not deviating away from these, and following RICS standards and professional guidance statements. We may also be asked a level 2 question reflecting on our own experience of some of the common causes of disputes, and this will obviously be personal to your own experience, but we could make reference here to errors and conflicting information within tender documentation, poorly defined change control procedures, a lack of knowledge or understanding of contractual obligations, errors within the contract, poor contract administration, poor quality of workmanship, delays to any payments or non-payment of claims, and finally, non-conformity of contractual obligations. We may also be asked a question on our understanding of the term or acronym TCC, and to address this we can say that TCC stands for the Technology and Construction Court, and this is a court specialising in construction and technology disputes. TCC cases are governed by civil procedure rules, and suitable claims assessed within the TCC would include any building or construction disputes, enforcement of cases adjudicated under the Construction Act, engineering disputes, and claims relating to professional services such as engineering, surveying, and accountancy. We may also be asked a question on our understanding of the term expert witness. An expert witness is an expert in their particular field who applies their knowledge, experience, and specialist training to assist the courts or parties involved within a dispute. They will provide their expert opinion in legal cases and disputes to assist the courts in arriving at a sound and reasoned decision. They are usually called upon in cases that require technical, scientific, or industry knowledge that only an expert in that field would possess, and this could be on complex issues such as boundary wall disputes, contractual disputes, insurance and injury claims. We'll now take a look at some questions on the various forms of dispute resolution, starting with firstly mediation. And to address this we can say that mediation is a form of dispute resolution that is entered into by consent of both parties. A third party mediator is appointed to resolve the dispute in question and assists in a supported negotiation to reach an acceptable outcome. Mediation is an informal process allowing parties to adopt a flexible approach in reaching an outcome, allowing relationships to be maintained. The mediator has no legal authority or power to instruct either party to do anything, and the process is not binding. We may also be asked a question on our understanding of conciliation, and to address this we can say that conciliation is used by mutual consent of both parties under the ICE procedure, and there is no right of either party to object to the appointed conciliator. The process adopted is very similar to mediation in a supported style of negotiation. The main difference here is that in the event negotiations break down, the conciliator will prepare a recommendation setting out how the dispute should be resolved. If neither party objects to the recommendation within 1 month of the ruling, then this becomes the final and binding decision. The next question we'll take a look at is what is adjudication, and to address this we can say that adjudication is a statutory procedure provided by a third party independent adjudicator who is selected by the parties in dispute. The parties can select the expert or highlight characteristics that they need to offer, and the appointed expert can act in a investigative manner. There are no legal submissions or examinations of evidence, and adjudication is often less expensive than litigation and arbitration procedures. The outcome issued by the expert is not supported by statute, with the expert's powers limited to the confines of the contract. The expert outcome must be enforced by court proceedings if appealed.
We may also get a follow-on question to this, asking our knowledge of formal forms of dispute resolution, and to address this we could reference arbitration, litigation and adjudication. Another question we may be asked in relation to this area is what factors would you consider when selecting a form of dispute resolution? And to address this, we could say that we would need to review the cost in proportion to the value of the claim, the timescales involved, and any impact on business relationships and reputation. The next question we'll take a look at is what is conciliation? And to address this, we can say that this dispute resolution is similar to mediation. It is where an independent party aids an agreement. The conciliator has no authority to seek evidence or call witnesses, and the conciliator cannot make formal decisions. A conciliator will normally be there to encourage the two sides to come to an agreement between themselves, whereas a mediator will often suggest their own solution. The next question we'll take a look at is what is mediation? And this is a ADR form of bringing in separate impartial third parties to mediate and guide a decision which optimizes the parties' needs. Mediation encourages coming together of parties and reaching an agreement. Another follow-on question we may get is what is the difference between mediation and conciliation? And to address this, we can say that the mediator is a neutral party who helps parties rebuild business relationships and helps them work out a solution that is mutually agreeable. The parties are directly engaged in the discussions, it is not binding, and parties can revert to arbitration or litigation at any time. Whereas conciliation has the same aims as mediation, but the processes are different. The conciliator is usually a figure of authority that the parties have turned to for guidance. The conciliator will make suggestions and the parties will then make the final decision. We may also be asked a question on our understanding of negotiation, and to address this we can say that parties may, through an informal private or facilitated negotiation process, agree to settle the dispute either at a high level or in detail and agree to be bound by this settlement. The next question is testing our understanding of adjudication. And to address this, we can say that this is a UK statutory dispute resolution procedure. It is relatively a quick process from submission of referral. It is binding until the dispute is determined by litigation or arbitration. And it's seen as a simplified arbitration process. The next question we'll take a look at is what enforces the requirements for a building contract to contain provisions for adjudication. And this is a very specific answer that we need to give, referring to a piece of legislation known as the Construction Act. So this is the Housing Grants, Construction and Regeneration Act. We may also be asked a question on what would happen if a building contract does not contain provisions for adjudication. And to address this, we could say that parties would have the statutory right to adjudication, assuming the contract qualifies under the Construction Act. The scheme for construction contracts will apply in its entirety. We may also be asked a question on our understanding of arbitration, and to address this we can say that arbitration is a procedure for the resolution of disputes which is under the control of the parties. We could also say that certain conditions must be met, for example a genuine dispute or difference between the parties, and a binding agreement must be in place to submit the dispute to arbitration. There are different opportunities available under this process, including documents only, a short hearing and a full procedure. The next question we'll take a look at is, can you explain in detail the difference between arbitration and litigation procedures? And to address this we can say that arbitration is where procedures are governed by the Arbitration Act 1996. In order to arbitrate, there must be an agreement by both parties. Parties have a wide degree of discretion as to a way of proceeding into how proceedings are conducted. The procedure is similar to litigation, with formal submissions by parties, expert evidence, hearings, and decisions by an arbitrator. The advantages are that it is a private process, parties have flexibility, and arbitration awards are generally easier to enforce. There are three types of arbitration. such as the short hearing, documents only, and the full procedure. Whereas litigation is the presentation of arguments in court. This is a public process following civil procedure rules. The advantages are that parties do not pay for court or judge costs. Processes can deal with multi-party disputes, and civil procedure rules aim for accessibility, speed and efficiency. The next competency we'll take a look at is health and safety. So again, a level 2 competency requiring us to demonstrate